On April 13, 2021, the Oklahoma Supreme Court released its opinion in the case of Fraternal Order of Police versus City of Norman. In this case, the FOP filed an action for declaratory judgment and injunctive relief against the city. The FOP claimed that the city violated its ordinances and the Open Meeting Act by enacting amendments at a special meeting that were not included on the posted agenda. In upholding the decision of the trial court, the Supreme Court concluded that the city's posted agenda did not provide sufficient notice to the public that certain potential amendments to the budget known to the city prior to posting the agenda could be considered at the special meeting. The court further found that the language used in the agenda was deceptively vague and likely to mislead the public. As a result, the action of the council constituted a willful violation of the Open Meeting Act. Because the city failed to post a valid notice pursuant to the act, the city's amendment of the budget and subsequent approval was invalid. The court considered a few different rationales to justify the sufficiency of notice to the public of potential amendment of the budget at the special meeting. First, the city argued that the term consideration encompassed amendment to the budget, but the court was not persuaded by this argument. The opinion noted that a person of ordinary education and intelligence would have understood that the city council may or may not approve the proposed budgets. The language of the notice did not include the possibility of, quote, amendment. Second, it was argued that the list of attachments to the agenda specified certain amendments to the budget, and therefore notice to the public of potential amendments should have been gleaned from the attachments to the agenda item. The court was not persuaded by this argument, but instead found that the list of attachments on the agenda did not provide notice to the public that new additional amendments would be entertained at the special meeting. At most, the attachments provided notice that the council would consider the items contained within the attached June 12th document. The court focused on the proposed action section at the bottom of the agenda, which simply allowed for council to adopt or reject the city budget. The court found that a person of ordinary education and intelligence would not have understood that the council could introduce and adopt new amendments to the proposed budget. As you might imagine, this decision has resulted in considerable discussion among municipal attorneys. Most of us attempt to write agenda language succinctly enough to cover the items desired for discussion by the City Council, yet broadly enough to allow for all possible action by the elected officials. Of note was the court's repeated use of the phrase amendment to the budget. A budget amendment is typically considered to be a legal term of art and denotes an action that takes place after a budget is approved in accordance with the provisions of the Municipal Budget Act. However, while acknowledging the provisions of the Municipal Budget Act, the court focused on meshing that statute with the Open Meetings Act's statutory provisions and agreed with the city's argument that the only way the governing body of a municipality can add or increase items or delete or decrease items in a transparent manner is by amendment during a public meeting, provided that there is advance notice that potential amendments may be considered at the public meeting. The court was clearly focused on what was known by the city regarding possible amendments to the budget prior to the posting of the notice of the special meeting. Despite the less than desirable outcome for the City of Norman, this case presents a wonderful opportunity and reminder to carefully review agendas to ensure that they are compliant with the Open Meeting Act. Knowledge of potential action by a City Council at a special meeting should be included in a notice of special meeting to alert the public of such possible action. Because it is somewhat difficult to fully anticipate all potential action by a City Council at a particular meeting on any particular item, a strategy that has been discussed by municipal attorneys is placement of a sweeping caveat of potential action on the agenda itself. Some of the recommended language could include the following. Official action can only be taken on items which appear on the agenda. The public body may adopt, approve, ratify, deny, defer, recommend, amend, strike, or continue any agenda item. When more information is needed to act on an item, the public body may refer the matter to the manager, staff, or the town attorney, or back to a committee or recommending body. Under certain circumstances, items are deferred to a specific later date or stricken from the agenda entirely. Because the Norman case specifically involved adoption of the annual budget, many municipal attorneys are adding language to their agenda item, which would allow final revisions to the budget at the meeting where it is considered and approved. In many municipalities, approval of the budget by resolution is somewhat anticlimactic, as most discussion and decisions regarding allocation and appropriation of public funds in upcoming budget years have already occurred in prior properly posted and held public meetings. Formal adoption of the budget merely formally finalizes these prior discussions. However, if potential deviation from these prior discussions and actions are possible in the final public meeting where the budget is formally adopted, then including notice to the public that such amendments may occur would be advisable. This case serves as a good reminder to thoughtfully draft, review, and provide advice regarding appropriate language for the agendas of your cities, towns, and public trusts. OAMA, providing support to municipal attorneys through education, information, and collaboration since 1986.